Everybody say, say, how can I express my gratitude for all the many things you've done for me? Words are not enough to say thank you. So Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things you've Father, you done for me, yeah. Words are not enough to say thank you. So Lord, you are, you're my everything. See, I call you Jireh. Lord, my provider. I call you Nisi. You are my banner. I call you Rapha. Hey. You are my healer. Say, Lord, you are. You're my everything. I call you Jireh. Lord, my provider. I call you Nisi. You are my banner. I call you Rapha. You are my healer. Say, Lord, you are.
Hello, lovely people, and thank you for sticking around with us for another edition of the Community and the Law. My name is No Recourse. This afternoon, we're looking at a step-by-step guide to getting the no recourse to public fund condition on your stay here in the UK removed. Our resource person and our guest from BWF Solicitors is Charles Asma, lawyer Charles Asma, and he will help us through that. We're live on BWTV and BWF Solicitors at YouTube at BWF Solicitors, so to speak, and Facebook at BWF Solicitors. So join us live now, the Community and the Law.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Oh, you clicked on it. Okay, lovely people. Yes, welcome back to another edition of the Community and the Law. My name is Oriku Frimpon. I'm coming your way courtesy BWF Solicitors, our trusted partners when it comes to the law. BWF Solicitors is located on the fourth floor of the other house, 214 to 218 Tottenham High Road, Seven Sisters in North London. They work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. And when you go in there, you have a warm welcome, a good smile, confidence in whatever it is that you're sending to them, that they will sort everything out for you. And then again, you walk out with a big smile on your face. So trust BWF Solicitors. Visit them. Call them on 0208 493 7340 0208 493 7340. Now, this afternoon, on our main discussion, we're going to have step-by-step guide as to how you can get the no recourse to public funds removed from your condition here in the UK. Lawyer Charles Asma will be helping us. And for that, let me first of all introduce Lawyer Charles Asma, a resource person and guide from BWF Solicitors. Lawyer Asma is right here with us. Let's see what it is. Let's push him right into his stream. Thank you very much, Lawyer Asma. How are you?
Fine. How are you, Brakuku?
I'm very well, thank you. Um, we're so glad and happy to have you with us here this afternoon. And as I keep saying all the time, we don't take for granted the time and the resource you share with us. So, on behalf of all viewers, clients, friends, family members, and all the other people that are watching us, we appreciate you. Thank you so very much.
Thank you. Pleasure to be here.
Right. So, folks, those of you who have joined us, let's announce ourselves on the platform in the comment section below. Let's look at who is here. I will welcome you. But before then, somebody is happy with BWF Solicitors. Eric says BWF Solicitors provided me with excellent service for my leave to remain visa. Lawyer Bernard and his team were instrumental in guiding me throughout the process. Their knowledge, professionalism, and attention to detail were commendable. I highly recommend their services to anyone seeking assistance with visa applications. I am gratefully thankful for your outstanding support. BWF Solicitors, I think we shout that, and I would want you to also enjoy that. So visit BWF Solicitors, as I told you earlier on, and things will go very well and right for you. We have entered into a new month, and the month of April is right here with us. We're going to go through that. But in the month of March, BWF solicitors, both in the UK and Ghana, in Accra, so to speak, we have our staff working so very hard, and the lots have fallen on one of our colleagues who has been voted employee of the month. And we're going to say congratulations to our legal assistant, Emmanuel Ampiao. Emmanuel is our employee of the month. Congratulations to you, sir. Emma, keep doing what you're doing. We appreciate you. And you know your reward is available and waiting for you. So, yes, Emma, congratulations. You are our employee of the month. Yes. In April, we'll be looking out for members of staff and we'll be appreciating them as well. But let's also move on. I am going to give you this, as I do once every month, your rights. All migrants have access to free primary health care. So the question obviously is, did you know migrants in the UK are entitled to free GP consultations and primary healthcare services, regardless of their immigration status? Let's go through it. Let's see. Yes, GP and nurse consultations in primary healthcare are free for everyone, including migrants. Treatments provided by GP and other primary care services are also free of charge. So remember, you can register as an NHS patient or access NHS services as a temporary patient. So then the question is, who is a temporary patient? A temporary patient, by definition, is a person staying in an area for more than 24 hours and less than 3 months. I know those of you who have really followed us, we know that when you are giving a visitor's visa, for instance, it's for a certain period. When Lawyer Charles Asma comes on, I'll ask him about that. So it's saying that if you are in the UK as a visitor, you are a temporary patient when you need to access medical care. And the right is that you have access or you can access um, primary care for free, as it were. Okay, let's move on. Let me give you further details of that. Free GP services. When you are accessing that, do you need to provide any proof or evidence? What are your rights? Let's look at that. Anyone in England, including migrants, can register and consult with a GP for free. No proof of ID, no proof of address, or immigration status is required to register with a GP. NHS guidelines prohibit GP practices from refusing patients based on their immigration status. So know this, if you are refused registration, the GP must still provide urgent treatment for up to 14 days, and this can vary according to your circumstance. The GP must give a written explanation to the patient for refusing registration within the 14 days. And remember, this is a requirement under the Standard General Medical Services Contract and the National Health Services General Medical Services Contract Regulation 2015. Furthermore, let's go on. What do you do if you face issues registering with a GP? What do you do? Contact your local NHS England area team, reach out to the local patient advice and liaison services for assistance. Listen and remember, you have the right to access GP services no matter your immigration status. We move on. Other free services beside GP services include A&E, that is accident and emergency treatment, excluding follow-up care. So you can go for, like, when something happens, accident and emergency unit will look after you. But following up, yes, you would have to have proper registration or probably pay for that. What do you access for free as well? Diagnosis and treatment of infectious diseases, family planning services, then compulsory psychiatric treatment, you would have to have free access to that. Then there's also treatment for conditions caused by torture, female genital mutilation, domestic violence, sexual violence. And again, remember, the services are free regardless of immigration status. We move on. So, free healthcare for ordinary resident migrants. Some migrants in the UK do not need to pay the NHS surcharge to get full NHS access. So then the question is, who qualifies as ordinary resident in the UK? British citizens, naturalized British citizens, foreign nationals with indefinite leave to remain. If you are lawfully settled in the UK, you are entitled to full NHS care without extra fee. So these are your rights. And as I said, BWF Solicitors is kindly helping us to know these things so we can stay on the right hand side of the law and also make sure that our human rights are respected here in the UK. Laura tells us, well, let me quickly come to you and ask, we were talking about between 14 days and 3 months. Does it necessarily say or mean that such people may be visitors to the UK?
So if you can look at that particular
Yes. So
bit.
if we could go to, I think it's slide number 3, maybe. We look at that. Maybe it's 1 or 2, one of them. Let's go back on that. So Lawyer Charles will pick the one up. The one that says you could have, try one for me. Yes, this is the one. Primary care for all, and who is a temporary patient, and saying a person staying in an area for more than 24 hours and less than 3 months. My thinking, and maybe I'm wrong to assume, is that a visitor in the UK can access medical care for free, at least for the first 14 days, isn't it? You're mute, sir.
Other protracted care needs. The primary care is where you walk in and the GP will make a general practitioner of medicine will
Hmm.
make a general assessment of and give you medical, let's call it advice.
Okay.
Now, at that point, you are not coming for full on treatment. So
Okay.
you don't go to a GP for treatment. You go for GP for primary care. So primary care simply means that anything that you don't have to do at home, you go to the GP to support you with. And
Okay.
if whatever when we say don't have to do at home, we're looking at self-medication.
Hmm.
So if you don't have to self-medicate, then a practitioner must tell you what to take. So if you're a visitor,
Hmm.
anything can happen, and you need medical guidance on
Right.
how to treat yourself. That primary level of care. And so even if you're a visitor, you can attend attend a GP practice for primary care.
Okay.
This is different from where the GP is making a referral for you to see a consultant and so on and so forth.
Okay.
And so if you're a visitor, normally we say that if you're a visitor, you can't go to a GP, you can't do that. But if you're a visitor, first off, it's not the fact that you are in the UK temporal, but also your human right.
Okay.
And so on the basis of human rights, you have access to a primary care by attending a GP practice. Ordinarily, the GP practice will have your record so that whenever you come again for advice or for general assessment, they will be able to look at your history and support you. And that's why, in that case, even if you're a visitor, you can have recourse to GP and have a GP registration set up for you.
Right. Okay. So yeah, that explains it. And thank you so very much, Lawyer Charles Asma. We will move on and look at our nuggets. We've known our rights, so we're moving on to look at our nugget, the piece of information that helps you to enhance your knowledge of the immigration issues and all legal issues here in the UK. So our nuggets 04 is talking about what we brought out earlier in the week. And we're going to get you in on that. And then the question is that did you know you may be entitled to compensation if you are wrongly detained at the airport? Yeah. I know sometimes when you get to the airport for very various reasons, they ask you, stay here. We're doing some investigations. They put you in a room. You stay there for hours on end. Question here is, did you know you may be entitled to compensation if you are wrongly detained at the airport? The Secretary of State has the power to detain and examine every migrant who arrives in the UK at the port of entry. However, they must be, or that must be balanced against the benefits of swift and fair decision making on entry, where the Secretary of State for Home Department goes against her published policy. It may render the decision to detain unlawful, leading to the award of compensation against the Secretary of State. This is a case, R. Tazim versus the Secretary of State for the Home Department 2025 case, English and Wales Court of Appeal case 347, really. Lasma, this sounds
Thank you
good.
very much. Yes, thank you very much. So we are looking at a duty placed on the Secretary of State
Mhm.
to ensure that care is offered to anybody
Mhm.
as far as the person is dealing with the Secretary of State or the Secretary of State is dealing with the person.
Yeah.
And here we are looking at a tortious obligation and we are entering into a law of tort where everybody must ensure that other people or others are treated fairly and justly.
Yeah.
What is fair treatment? If you hold my arm, for example, so that I'm not able to move it down to move freely, that is restriction, isn't it?
Yeah.
If that restriction is not warranted, then it's a way of taking away my liberty.
Mm-hmm.
This is not crime, but it's about the fact that you have not been fair to the other person taught. So the duty of care to other people here, we are looking at people who come to the UK through the ports. If somebody has been cleared to enter or to come to the UK, they
Mm-hmm.
have to be cleared again to be able to pass.
All right.
And that's the entry permit. So you may have the entry to come, which is the visa, but you have to be cleared at the port.
Okay.
Sometimes the immigration officer will have a reason to do some checks. And for that matter, they have to hold you for a moment.
Mm-hmm.
That is called detention. So, for the purposes of doing their job, is it lawful for them to detain you? Yes. But is it lawful for them to detain you unnecessarily? That one is no.
Okay.
So, what is necessary detention and what is unnecessary detention? So, when the detention becomes unnecessary, then the Secretary of State has breached its duty of care to that individual. And that is the area of tort law. That's equity, fairness, justice. So the person has come in. You say that the person should not be able to enter the UK
Mm-hmm.
because of what you see. So you are finding time to check.
All
You've
right.
done your checks and you come back to say that, oh, right, we are okay. And then you say, hold on, let's try something else. Between the time you said you are okay and the time you say, wait, let's try something else, which one? Then we have to look at when does it become unlawful?
Mm-hmm.
Is it at the point where you said okay or beyond that? It will be beyond that, isn't it?
Yeah.
Because at the point you say you are okay, that means you are satisfied. Maybe you check to see whether the family they are visiting is as it is.
Mm-hmm.
Maybe the reason for entering the UK, all those things you have checked. And you have said that it's okay. Then you say, hold on, for example, you are going to check something else. And the person waits for another hour, 2, 3, 12 hours. Then that extra hours have become unnecessary. And then from that point where you said you are okay to the time the person was still with you, the detention will be unlawful. Because there's no justification to keep the person if you have said that you were okay.
Yeah.
Because if you are not okay, then make sure you do everything you have to do.
Before you tell me it's okay.
But that means once you say you are okay, and me knowing that you are competent enough to know what you are doing, your job, then you cannot turn around and say, oh, I forgot one more thing.
Mm-hmm.
And so, when the person is able to assess that the Secretary of State has detained the person beyond necessity or the
Okay.
level of necessity, then it becomes unlawful detention. Is unlawful detention justified? There's no justification. And at that point, the Secretary of State would have breached its duty of care. And the person can bring action in tort against the Secretary of
Against
State
the
for
Secretary of
unlawful
State.
detention.
Okay.
And the person, the remedy for breach of tort or breach of duty towards that person, immigrant, is that it will be award of damages.
Okay.
So if as a result of keeping me, I've wasted too much time, and it's not just about the time, it's about everything that is happening to the person per the action of the Secretary of State through its agents and assigns the border force.
Okay.
And so there's also what we call vicarious liability on the part of the Secretary of State because the people are acting for him or for her. And so in the case of Tazim, the case in contest 2025, the court concluded that the Secretary of State made it clear, the border officer made it clear that they were done with the checks.
Mm-hmm.
And then they held the person again for extra hours. And the person sued in tort that there is a breach of duty on the part of the Secretary of State through the border force agent or officer for unlawful detention. Because at the time they were still keeping him, it wasn't necessary. because they were satisfied with everything.
Yeah.
And so the award will be award in cost, financial damages, and it will be assessed on the basis of everything that has happened to the person. If there has been issues to do with emotional trauma, and so many other things, then that will increase the fee award. And therefore, depending on the time involved and the damage caused to the person, the fee will be more or the fee will be okay. So there is always a duty on the Secretary of State to ensure that people are not detained beyond the level that is necessary for them to do their work. If you are able to finish or conclude and you give a hint that you are done, you have to release the person. Anything from that point becomes unlawful detention, and the individual has right to bring action against the Secretary of State for that unlawful detention. And it is a court that will make an assessment to award the person damages. That will award damages against the Secretary of State in favor of the person.
All right. So you have had the explanation from our very own lawyer Charles Asma, and later on at the tail end of the program, I'll be asking you my usual quiz question. I'll give you a scenario based on this nugget and ask you to give me the option that would be best for a person who would be in that scenario. You're live with us on BWTV, and the program is The Community and the Law. Now, this afternoon, we're going to look at some guidance as to how we can get no recourse to public fund condition taking off your immigration status. Stick with us. Want to say thank you to BWF Solicitors, and after this break, we'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back, and thank you for sticking with us. We're live on BWTV. Let's take another quick break. We'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884. Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884. Based in London, we are a dynamic award-winning firm specializing in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specializing in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884. Based in London, we are a dynamic award-winning firm specializing in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specializing in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Yes, welcome back, and thank you for sticking around. We live on BWTV, and we still doing the discussion on how to get the no recourse to public funds off your immigration status. Lawyer Charles Osma is here, and thank you for your patience. Thank you for your time. We're going to go into that discussion. Now, Lawyer Osma, good afternoon once again, and let me ask this very first question by asking, no recourse to public funds. What are we talking about?
Thank you very much, Brakuku. So, The wording there is clear. No
Mm-hmm.
recourse means no access, and
Okay.
public fund is state fund. So no
Okay.
access to state funds if you don't qualify to access or to get it. There is policy angle. Of course, it is a policy.
Mm-hmm.
And then we look at the legal side of things. We have a couple of resources to look to before we go into the calculation. So I'm going to spend about, we'll use about half an hour to go through the legal basis, then,
Uh,
or 20 minutes,
then
20
we,
minutes.
we should
So
get
that,
ourselves ready to go into the classroom, isn't it?
exactly, so that people understand why they can be refused and why they cannot be refused.
Refused. Okay.
You know,
Right.
BWF will come to tell you what the law is and what the policy is. So
Okay.
that when we
So
are
let me let
fighting
me
your
let me
case,
quickly grab my resources so I can readily share all those things with you. So yeah, um, go on with your definitional issues whilst I go to get my stuff.
thank you very much. So the policy is this. On the 9th of July 2012, the UK government comes up with a policy that those who enter UK temporarily cannot have access to public fund. And so there will be a specific focus on the use of such public funds, taxpayers' money.
Mm-hmm.
And so until the person has settled in the UK, they cannot access the fund. That's first point. 9th of July 2012, the policy, no recourse to public fund for immigrants who have limited access in the UK cannot go close to the public fund.
Okay.
The question is, what is public fund? We've understood that public fund is taxpayers' money for social intervention, social purposes. And here, such money allocated for social purposes, we are looking at for housing support,
Mm-hmm.
for the, essential living needs support. It used to cover education, attendance, allowance, and so many other things. For
Right.
now, it's been simplified into universal credit. And so universal credit is a form of public fund and all other support, disability support. So we know what public fund is,
Right.
benefit, simply. So who qualifies? Only those who do not have immigration control qualify. Indefinite leave to remain and citizenship or people with citizenship
Okay.
generally. Then we go to the UK spectrum, where because of UK angles, EU spectrum, where because of the treaty agreement with the UK or the EU, then UK being part of the bloc means that whatever UK will give to its citizens, they must give the same thing to EU nationals. Otherwise, they will be seen to be discriminating. So EU nationals also had automatic access to public fund because they were seen to be people with indefinite or citizenship because they are all union citizens.
Mm-hmm.
So that's the second angle in terms of who qualifies. Then we come to the number of people who don't qualify. That means if you enter the UK with 6 months visit, no. You enter the UK with student visa, no. You enter the UK work permit? No. You enter the UK with to join your wife or husband? No. You enter the UK to join your parents? No. Because you do not have indefinite leave to remain. So it's clearer then.
Okay.
If you don't have indefinite, you do not have access to public fund. But then because it's a policy, it became an indictment on what the British government or society itself espouses: liberty, prevention of degrading situations for people, inhumane treatment, torture, and so on and so forth.
Mm-hmm.
And so Article 3 of the European Convention on Human Rights became a point where people cannot be tortured. People cannot be subjected to inhumane treatment, and people cannot be subjected to degrading treatment and punishment.
Mm-hmm.
So, for example, if I don't have access to public fund because I have I don't have indefinite or citizenship, and I'm not able to afford my needs because I don't have a job or I can't find a job, and I'm going to be on the street. I'm going to be I'm going to be destitute, and I will be sleeping rough and begging and not able to find food to eat. These are degrading situations, aren't they?
Yes, they are.
And so, saying that I do not have access to public fund because of my circumstance is you telling me that I cannot exercise my right enshrined in Article 3 of the European Convention on Human Rights, and therefore there's incompatibility, the policy angle.
Mhm.
So, we look at Section 115 of the Immigration Asylum Act 1999, and it gives parameters people who do not have access to those benefits or those support, all those who are subject to immigration control. Can you please have a quick look at that law, the last resource on your the last resource, please?
So we're talking about the Immigration and Asylum Act of 1999, right?
Yes.
And it says that Immigration and Asylum Act of 1999, Section 115, is up to date with all changes known to be in force on or before 3rd of April 2025. There are changes that may be brought into force at a future date. Changes that have been made appear in the content and reference with annotation. So 115
Okay.
is talking about exclusions from benefits, lawyer.
Right. Good. So that means exclusion from benefit. These people will be excluded from benefit. Now, I want you to go down to 9, please. Go to 9, and we'll come back to 1.
Now,
9.
F9 says housing benefit.
No, no, 9, 9. Subsection 9.
Subsection 9, okay. Um, 3.
Okay.
A person subject to immigration control means a person, which is annotated F8, who A requires leave to enter or remain in the UK but does not
1.
have it, or B has leave to enter or remain in the UK, which is subject to a condition that he does not have recourse to public funds. C has leave to enter or remain in the UK as a result of maintenance undertaking, or has leave to enter or remain in the UK only as a result of paragraph 17 of Schedule 4.
Good. So what we are saying here is that this is a primary law. Act
Mhm.
of Parliament is a primary law, not even a secondary law. This is a primary law. So
Okay.
Parliament passes a law 1999 to say that Section 115, subsection 9, these people cannot have access to public fund. One, if you enter the UK with an undertaking that you meet the maintenance requirement. And a lot of people enter the UK and they say that they can maintain themselves, right?
Hmm.
And we show the bank statement and the pay slips, don't
Yeah.
we? So if after showing all that, you come close to the money, then you are contradicting what you said, the undertaking you took. So
Yeah.
if you look at C, it says, and those who have undertaken. And if you look at the other one, it says that those who come in with limited leave, and so on and so forth. So
Yeah.
let's put all that together to say that those who enter the UK with limited leave to remain or with visitors visas do not have access to public funds. What are some of these public funds? That is under Section 1151, which I have already explained. So we are not going to go back to some of the public fund, but the main one is credit, universal credit, child benefit, disability allowance, and all that. So
Hmm.
sorted. And another one, which for the purposes of this conversation, people will want to know is housing benefit, which is part of it anyway. Right.
Okay.
Now let's look at what has changed. So if you move to the last but one resource, please. The last but one resource,
Yeah.
quickly.
It talks about public funds accessible. Is that the one?
Yes.
Okay. So we read that, and about this guidance reference. What are public funds for immigration purposes? Would I read? Would I be okay to read that one?
So what it says, what are public fund for immigration purposes? Which we know that for immigration purposes, public fund will be the benefit that people who do not qualify cannot have access. But
Mhm.
with this particular guidance, it shows yes that bit. If you read that particular paragraph for us,
Permission to enter?
permission to enter.
Yeah, permission to enter the UK is also known as leave to enter. And no recourse to public funds condition can be applied to a person's permission to enter the UK. Permission to stay in the UK is also defined there as well.
All right. So here we are looking. They are context as to what are these permissions and whether such people will have recourse to public fund or no recourse to public fund. So all these people who have recourse to public fund, they have been assessed not to qualify or not fit to access public fund.
Mhm.
So under this guidance, it is clear that there are some people who cannot access. And the only point where you have access is where you have exceptions or you have a waiver to access.
Okay.
So if you haven't been granted a waiver to access, then you cannot access. Any intention to access, you must apply for the condition to be removed, which will be the conversation shortly. Now let's go to the legal, the policy and the legal part. What has changed? So we
Mhm.
go to 2018. You don't have that one, so don't worry. We go to
Okay.
2018, where the conversation started. You know, we have civil society groups that come together to assess policies and whether they are working or not, just like we've had with care workers. And they say the
Okay.
policy is not working, so they have to cancel. So in
Mhm.
2018, they started having a conversation about no recourse to public fund and whether it is a punishment or support to upholding well-being and development of people. And the conclusion was that it is not meeting its purpose because it appears to be that it has a blanket approach to treating everybody who does not have indefinite or British citizenship. So there should be some distinction between those who should be given opportunity to access and those who cannot be given opportunity to access.
To
So you
access,
can
yeah.
see that from 2018, the law began to think.
I like that.
And so after thinking through, it became a point that we have to open it up so that those who have reasons to access can be given opportunity to access. And so in 2020, for example, in 2020, for example, 2020 was COVID, right?
Mhm.
COVID was um, very, very endemic at the point. It was causing havoc. And yet, those who do not have access to public fund could not seek help. That is a law, a policy that doesn't have conscience. So somebody took the government to court. Actually, it was about a child supported by a friend, legal friend. They took the government to court that why will you have a law that does not have conscience?
Yeah.
So that everybody cannot access public fund, even if they are going to die. But you same government say that you have subscribed to Article 3 of the European Convention on Human Rights, which says that people cannot be subject to degrading situations. So for not allowing me to have access to public fund and allowing me to die, is it not against my Article 3 right?
Obviously, yeah.
And so the case came from the court, and it says that that policy, no recourse to public fund, is incompatible with Article 3 of the European Convention on Human Rights. So then the conversation opened up that all those who can prove that they are in certain conditions or facing degrading situations can
Mhm.
apply to access public fund. So you realize that 2020, 2021 up to date, there have been a range of applications, a number of applications to have the recourse removed, to have the no recourse removed.
Removed.
Then we go to 2021. Again, there was a case um, that went to court, and the court concluded the same way as we have in the case of R acting for W versus Secretary of State. 2021 is a case of ST and VW, again, children. First one was a child, this time again, two children through their legal reps. They went to court challenging the government. And the court concluded that yes, this policy of no recourse is incompatible with Gen 1.11 capital A, Gen 1.111 capital A.
Mm-hmm.
And what does it say? Gen 1.1 capital A, we're not going to go into that, but it simply says that people who are destitute, people who are becoming imminent destitute,
Okay.
should not be subjected to no recourse. Because if I'm a destitute, then I'm sleeping rough. I can't even afford my essential living needs.
Mm-hmm.
And that is my Article 3 taken away from me.
Okay.
Those who are going to also fall into that situation, my Article 3 taken away from me. And so the court concluded in the case of ST and VW, the Secretary of State, 2021, that again, those children whose parents are facing such degrading situations should be given opportunity to access public fund. So
Okay.
they had to apply to have the no recourse removed.
Okay.
Then again, the Secretary of State was told that that law of no recourse to public fund does not take the needs and interest of children into consideration. And therefore, it's a breach of Section 55 of the Borders, Citizenship, Immigration and Asylum Act of 2009, and has become something we say all the time, Section 55, best interest of children. So again, court ruled in the favor of removing no recourse or giving opportunity to people with limited leave in the UK to have access. Then again, we go to the case, another angle in 2022. So we are traveling through the time
Mm-hmm.
to see what has happened. That will warrant our discussion. So in 2022, again, the court ruled that there is danger to Article 3 if the Home Office continue to tell people or everybody not to have recourse to public fund. And so in that particular case, there was an award against the government for damages on the basis that individuals' Article 3 rights have been endangered. Then we are in 2025. So before 2025, 2022, we then look at 2022 again itself, another case in court where children took the government to court on the basis that the Home Office policy guidance, which is called version 16, which says that it will give opportunity for people who cannot afford to access public fund, has been breached or has not been followed. And so the decision to continue to have no recourse for some people is unlawful and also in breach of Section 55. So in 2025, we are having a conversation that now that we know that people can apply to have the no recourse removed, how do we do it? What are the step-by-step guide? That means even though the government says you can go for it, it is not easy that they will say, take it if you're not able to do your job properly.
So in a sense, what it is that you would have to assess yourself to see whether you qualify under any of the conditions or the thresholds. Then you can do or make an application to get that removed officially. Question then is, why don't they then cancel the policy altogether? Because my Section 3 rights, or Article 3 rights, so to speak, I think that's the right expression. Article 3 rights allow me to enjoy these benefits if I can contribute to the pot, can't it?
But what does Article 3 say? Article 3 says that nobody should be subjected to inhumane, degrading situations and torture.
Mm-hmm.
The word is subjected.
Okay.
So the moment I do something to put you into that situation, that is where your Article 3 will be engaged.
Okay.
So the Secretary of State will only engage you Article 3 if they say that, one, they won't let you have it, even though you don't have it yourself.
Right.
What it simply means that if you cannot afford your needs, and the government is restrictive on giving you access to the port to be able to access your needs, then Article 3 will be brought into question.
Okay.
But what about those who can afford? Has that got to do with the Article 3? If you can
Um,
afford, if you
well,
can
if I can
afford,
afford, I don't even
then,
need to ask the question anyway.
yeah, so if you can afford, that means it's not like you are sleeping rough.
Mm-hmm.
It's not like you can't eat 3 times a day.
Yeah.
It's not like you can't wear clothes.
Mm-hmm.
And so these three basic needs, if you can afford, then you don't need government to buy for you.
Okay.
But
So in determining who can have it, um, it's not just a given, but you have to apply and it will be assessed. When they do the assessment, they can tell you, no, you can afford, so we won't give you.
yes, so if you look at the case law from 2020 to 2022 and even
Mm-hmm.
up to date, the conclusion is that it is means tested. And so
Okay.
if you can prove it, you are likely to get it.
All right. Then I am thinking that in the steps and the guidance that you're going to take us through next, um, the means testing criteria will come in, and then you would have to prove that you can't afford. You don't just tick boxes, but you have to prove that you can't afford. Would that be right?
Yes. So the caveat here is that if you're a visitor, this is not for you. This is for those who have lived to remain in the UK
Hmm.
beyond visit.
Okay.
Live to remain in the UK beyond visit.
Visit.
So you are living in the UK as a student. You have no recourse to public fund.
Hmm.
If it is the case that your Article 3 and that of your okay, so let's look at something unique here. All the cases that have been to court, who do we see in there? A child.
A child, yeah.
You see a child. And so where there is a child and the child well-being is affected, then it is likely for you to make a stronger case
Hmm.
as opposed to you are if we're only dealing with adults.
Adults, right.
It doesn't also mean that if you're an adult without children, you cannot apply to be
Apply for
assessed.
the thing to be taken
But
away, yeah.
the presence of a child in such an assessment makes the case stronger. It adds extra points, literally.
Okay. Well,
Right.
so yeah, folks, then let's get ready, get our pens and papers ready. We're going to look at the steps that we need to take. What do we need? What documents do we need? What questions do we have to answer? And what answers do we have to give to those questions that will help us? Laura has just mentioned that when there's a child in there, it enhances your level of argument to say that it has to be taken away from my condition. We're looking at recourse to public funds, and for some conditions or some people, it says no recourse to public funds. It is stated on your card, on your records, on your e-visa, as it were now. But can we get it removed? The answer is yes. How? We're going to the next after this.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back, and thank you for sticking around. Is the community and the law, and it's brought to you by BWF Solicitors. As we have just stated, visit them and get your case and situation addressed. We are discussing this afternoon step by step as to how we can get the no recourse to public funds removed from our status and immigration situation here in the UK. Our resource person and guest is lawyer Charles Asma. If you have a question, you can put it in the comment section down below on Facebook at BWF Solicitors and on YouTube at BWF Solicitors and also at BWTV on both platforms. Or you can send us a text 07399208468. But when the lines are active, you can also call us on 0208 493 7345. Leasma, now I think we should be ready for the step-by-step guide. And yes, we are ready, and we are ready for you if you are.
Sure. Thank you so much. So we are looking at no recourse. We've understood what that is.
Mm-hmm.
Our question now is, how do I do it? Now that I know that I qualify.
That's right.
So we've looked at the key qualifications. We are moving into assessment.
Okay.
So we are going to look at the policy guidance on making application for no recourse to public fund condition to be removed,
Okay.
the eligibility and the evidence required.
Mm-hmm.
So let's go to resource number 3.
Okay.
Which is the first on the list.
Yeah, resource number 3 would be on in a minute. Just give me a sec. Bring it up. Resource number 3. Immigration and Asylum Act 99, sorry.
The no recourse to, that's the first on your list. Number 1 on your list.
Right. So it's talking about eligibility, which we've gone through. And then it has the second evidence you should provide.
Good. So we are going to go through the evidence, which will take us about 10 minutes. Then we'll look at how to apply the evidence to your fact.
Okay. So 6 months bank statement for all accounts held by all members of your household. Even these, those belonging to children or ones that are rarely used, these should include an explanation of any significant or a regular transaction or regular transactions, really.
Full stop. So let's break this down because this contains a range of criteria.
Right.
1, it says all, right?
Held by all members of your household.
It's a bank account held by all.
Mm-hmm.
So it didn't say some bank account. It says 6-month bank statement for
all members
bank
of the
account.
household.
Yeah. So somebody will say, all right, that it says that 6 month bank statement. I have 10 accounts. Okay, I will use one. That is in
Mm-hmm.
my favor. It is not what is in your favor. It is what is on the record.
That's right.
And the record here, we are looking at your own bank statement, your
Mm-hmm.
spouse or partner bank statement. That is if you are with your spouse or partner,
Mm-hmm.
your parents' bank statement if you are with your parents, and the child's own bank statement. Somebody will say, oh, but the child is just savings, but that is a child account. So I
That's right.
usually will ask people, how many accounts do you have in the world? That is my question to them.
Mm-hmm.
And they will say, oh, okay, I have 10. And I say, if you have 10, that's what they want to know. You can't pick and choose. Then after that, I will ask them, how about your child? How many accounts?
Mm-hmm.
Then anybody else in the household, how many? Because the point is all members of
Members
the
of the
household.
household. Yeah.
So if you're a single mother, it's just you and your child or you and your children.
Mm-hmm.
But if you're a single mother with a spouse, then you, your spouse, and your children. So let's assume that you have one. You have current account, you have savings account, and
Mm-hmm.
you have saving account. Some people even have three savings account. ISA, ISA, that, all of them. These are all bank account because they have bank account numbers.
Yeah.
So you have three. You have two children. They have two, making four plus yours, seven, right?
Mm-hmm.
You have your spouse. He also has two. So that's nine. And you have another one in the corner, making 10. And I'll come to the corner ones. The corner ones are the online ones that we think they are nothing, but they can be picked up.
They
For
can be picked
example,
up. Yeah.
Revolut, Monzo, Sterling,
There's one wise.
Wise, all these are accounts because they can find them by
Okay.
just using your details. So that is question. That's point one. Let's assume that you have three accounts. That means 6 months for each of them,
Mm-hmm.
and that is the point.
All right.
Then the next one, what does
The
it
next
say?
one says recent pay slips accounting for at the last 6 months.
Again, pay slips. Whose pay slip?
Yourself, the one making the application, isn't it?
But yeah, if I'm making the application, what about household, family members?
Um, this one doesn't say that clearly or explicitly, but it
What,
says
what
recent
does
pay.
it say? What does it say?
It says recent pay slips accounting for the last 6 months. You know, the
Okay,
first one says 6 months bank statement for all accounts held by members of your household, even those
yeah,
belonging to children or ones that are rarely used.
clear. So the second one is from the first one. So
Okay.
if you have pay slip, then you are working.
Mm-hmm.
So this one should have been 6 month pay slip for all those, all so 6 month pay slip for all working members of the
Members of your
family
family.
or household.
Mm-hmm.
But it didn't have to go to that bit because it's obvious that if you are living with your husband,
Mm-hmm.
then if you are working and your husband is working, then both of you must bring your 6 months
Your
pay
pay
slips
slips for 6 months.
for 6 months. If you have a child who is also doing part-time, then you have to add it. But we assume that children under 18 may not necessarily be working. They might just be
Okay.
doing voluntary work. And so the pay slip is likely to be the mother and the father or one of them, depending on who lives with
Is
the child
working. Okay. Then
or
the
working.
next one says breakdown of monthly monthly income and expenditure. So what comes in and what goes out?
So here, in simple terms, income and what?
Expenditure.
Expenditure. Home office will call it your income and your outgoings.
Okay.
So when I pick your bank statement, I want to see all the money coming in. Some people are doing susu, which is called informal credit groups, credit union, whatever. But it's a syndicated loan, it's a syndicated way of people saving money. Let's say there's Susu program going on, and you are the Susu manager. So all the money pass through your account.
Mm-hmm.
Then you have to be able to say that this is not my money, it is for somebody. because I'm a SUSU manager. Because all the caseworker wants to know is, where is this money coming from?
Coming from, and where is it going?
Where is it going? Imagine somebody who will say that I always pay £100 to Cancer Research UK because I'm kind-hearted, but I cannot afford my own needs.
Well, uh, I'll leave that comment there. But obviously, if my conscience tells me that even if I earn a little, I should share, why should I be
Yes,
punished for that? Should
I
that
agree,
trouble
but
me?
the conscience then will tell you that doing that means that you have cared for yourself first.
Okay.
Yep. So
Do,
that's that point.
the
So
good book says, "Do unto others as you want them to do unto you."
we are dealing with immigration rules.
Okay.
We are all faithful people, but we are dealing with the rules. And the
Mhm.
rules say prove that the money you are giving out is part of your essential needs
Okay.
spending.
Okay.
So they are looking at frivolities, giving once you are in trouble. So once they assess and they see that money is going out, but you can make a case that this money is sent to your parents for their bills, medical bills, and whatever, then that
Mhm.
is where morality will come in.
Okay.
Because morally, you should look after your parents,
Your
even if you
parents,
are
yeah.
not
Hmm.
able to care for yourself. It should be there for your parents. And on that basis, you make a moral case for you. But not when you say people are coming to me for help and I give them. I gave to John, I gave to Junior, I gave to this, I gave to that. Then they will say that all those people should also be able to come together to help you
And
to
help
survive.
you in the time of need.
That's what the book says, good book says, right?
Hmm.
Uh-huh. So you see, it's critical because we are looking at step by step.
Right.
So once you pick the application to submit for it to be removed, you are clear that you have about 80% chance.
Mm.
If it is weak, then you know that it's going to be turned down.
Okay.
So we've checked, we've done the ins and outs, and we realized that let's look at the first point. You have done the assessment, and
Yeah.
your income is equal to your expenditure. What does
Hmm.
it mean?
Then you don't have anything to say. And
But
in the case of emergency, you'll be in trouble.
but are we looking for money from the government to save?
Obviously, no. So if
Obviously,
if
no.
if you have enough coming in and it covers everything that you need to pay, then you don't have a problem.
So then can you go begging the government to give you a chance?
No, but you earn enough.
Exactly. So step one, you do your assessment. A is your income, B is your outgoing. Is
Hmm.
A equal to B?
Hmm.
If yes, don't go further because they will tell
Okay.
you that you are okay. You are not destitute.
Okay.
And you are not going to be destitute in the next 12 months. Unless you say A is equal to B. However, I'm going to be made redundant because there's redundancy process ongoing.
Yeah.
A is equal to B, but I'm going to go through maternity and my money will go down. A is equal to B. So the first one is A equal to B? And the second one is, will A be less than B shortly?
Hmm.
If your income is going to be less than your outgoing shortly,
Shortly.
then you fall into
So
the criteria.
potentially you could be a destitute person.
Exactly. Imminent destitution. Then we go to the next one. Is A less than B?
Hmm.
Now, if A is less than B now, it means you are destitute. You can
Yeah.
afford your outgoings. But the question, that is why we now want to see whether these outgoings are things you should bother about. And that's why
Okay.
we are going to take the outgoing list. We see food there. Is food okay for us to accept? Yes, because you need to survive.
Hmm.
Clothing, you need to wear clothes, so fine. Shelter, you need to pay your rent, fine.
Hmm.
Telephone, yes, you have to be communicable, even though you are destitute. you should be able to make calls to look for a job, right?
But if yeah, to look for a job, if you have a medical situation and your GP wants to
Very
contact you,
good.
they need to contact you through your
Good.
telephone.
Good. So telephone cost will not be a frivolity, it will be essential.
Okay.
We come to exercise, grooming, your hair, your going to the gym, entertainment. Are they necessary? Now let's stretch the policy argument. Somebody will say, if you don't, you can, if you can't afford, why will you go to the gym? But I'll go to the gym to be able to stay fit so that I don't fall into sickness, which will be a
Hmm.
burden on the state.
And for example, it be a medical situation where your doctor would advise you you have to be exercising, so you need to go to the gym.
But you don't want the doctor to tell you that, so you have been proactive yourself.
That's right.
You are paying for it. That will be
Hmm.
acceptable.
Hmm.
Grooming is acceptable.
Yeah,
Then
you
somebody
can't
will
look
say
shabby. Other than when people see you on the street, they'll run away.
they'll run away. Exactly. Yeah. So you see, yeah, you see, so in this case, we are not talking law. What are we talking about? Common sense.
Common sense, right?
Well, I can make a common sense argument that my telephone, my travel cost. Somebody will say, but you don't work. So why will you be talking about travel? I don't work, but I travel to look for help.
Hmm.
So this is the travel cost. Or I work. And so it's obvious that travel cost is essential. So we put all that together. Then your parents abroad, their essential needs. If
Hmm.
you have children abroad, their needs as well. And again, are you committed to any bills such as bank loans, credit card, and unpaid parking,
Hmm.
all those things you are paying for? Then that's essential because those are statutory commitments.
Mm.
So once we put all together and your income is less than your outgoings, then you fit or you meet the criteria.
Okay. So then,
So,
obviously, this one is also saying that we need to provide a recent tenancy agreement or mortgage statement that would show your part of your outgoing, if it's going to be on the high side to get you to be potentially destitute. Is that the reason that is put in there?
all right. So, I mean, you can see that some of the things we have here is literally your income and expenditure profile.
That's right.
So, rent is it under income or under expenditure?
Rent is expenditure.
Expenditure. So, if you claim that you are spending 650 on rent for one room, then bring the evidence, which is the rent agreement, isn't it?
That's right.
Yeah. Otherwise, you have to bring what we call lodgers agreement because some people are lodging and they are paying, contributing towards bills
Hmm.
or rent.
That's
So
right.
you have to bring that. So this is important. What about people who are not paying? They are paying into, they are paying cash directly to the person. What then you need a letter from the person that you have informal arrangement where they have given you a place to sleep and you are contributing to the bills and
That's
you
right.
pay X amount.
Right. So then this one is saying you need to explain what your current financial circumstances are, how these may be changed, and how you are currently maintaining yourself, as you have been explaining, lawyer.
Let's go up where it says P. Have you seen P45?
Yeah, recent P45 and P60. Let me see if I can highlight it.
It says all P60, right?
Yes,
Now, so P60, P45, they want to see how much you were earning before your
you are
claim
fired.
date of the point of claim.
Hmm.
So if you've been earning, for example, 30,000 just last financial year, and the next financial year is coming up. Oh, what's today's date? Fifth.
Hmm.
Yeah. So today is the end of financial year 2024, 2025.
2025.
So from next month going, P60s will come.
Hmm.
But P45 is likely to go in your favor because with P45, that is your transfer letter or your end of employment letter.
Hmm.
So if I have P45 and I say that I am now unemployed, this is my P45. I was earning X amount, but this money has stopped coming because I am no longer. Then that will make a case for you. If it's P60, then you have to show. But P60, P45, because you're able to provide pay slips, P45s and P60s are secondary anyway.
Okay.
Right. Then child benefit support. Now, here we are looking at child benefit. If you don't qualify, somebody say, I don't qualify for recourse. Why will you talk about child benefit? But you are baby mama. Baby
Mm-hmm.
papa or daddy is the person who has settlement or has British citizenship, and they have made a claim for child benefit for the child. And the money is coming to you. Won't you
Okay.
declare it? So that will go on the declaration form. Then the next one will be people who are giving you support. So they want to see what effort have you made to get help. Have you called charity? Is your church helping you? Are
Mm-hmm.
friends and family members elsewhere helping you?
So if I go to the food bank, for instance, should I ask them to give me evidence that I come to collect rations?
So food bank is just to say that you are relying on that food bank support, but that is food, isn't it?
Mm-hmm.
The food bank support does not extend to your clothing and your
Okay.
shelter.
Yeah.
So even though food is there, but again, it will just be temporary food because there are sometimes you go to the food bank and because you are not alone seeking help, the food is not enough, so you won't get it for that day.
Okay.
But you have to show what you have been doing. So I've been going to food bank and this is the evidence. But now it's no longer coming. My child is in dire need. I come, for example, diapers. I can't afford my child diapers. I can't afford my child milk. I can't afford this. I can't afford that for the child. Then it's not even about you. Who are you concerned about?
Your child.
Your child. And that's where Section 55 will come into play.
Mm-hmm.
Because Section 55 says that for you to make a better case, include child needs. That is part of your situation.
Mm.
It doesn't mean that if there is no child, you won't succeed. You will, but then there are certain things you cannot put in. If you are doing it for yourself and the child, it makes better sense than just yourself. But even if you are an adult, you can still make a case for that. Just that you have to then prove extensive evidence to support your claim as an adult.
All right.
Right. So we've done the side by side assessment and we have concluded that one, income is less than expenditure
Mm-hmm.
for a typical month. Then we have tipped that you are likely to get it. And I will profile it and grade it as 80%. You are likely to get it
Okay.
removed. I assess your case and I see that income is equal to expenditure. What grade will I give?
It's
Equal.
it's equal. So unless there's some external extenuating
Good.
circumstance,
I'll
it
tell
would
you
be
that
less than 40%.
Yes, I'll tell you that if you want to go and try, but it won't work because you are not destitute.
Mm-hmm.
And I will ask you, do you have evidence that you are going to be destitute, where your income will fall below your expenditure?
Expenditure, yeah.
Then you have to tell me. So, are you going to go on maternity? So your income will drop. Are you going to be made redundant? Your income will drop. Or you are on serious medication, medical treatment. So all those bits must come in. Or you have just received a letter from your bank that they are going to deduct payment at source because you owe them.
Mm-hmm.
Then your income will drop because you didn't factor that. So these things coming in shortly will make you imminently destitute.
Destitute.
And on that basis, you are likely you are unlikely to be able to afford your own needs and that of the child involved.
Mm-hmm.
So, three things are the things we are looking at. One, your income is less than your expenditure. You are likely to get it.
All right.
Number two, your income will be less than your expenditure because of what is happening to you now. You're
Mm-hmm.
also likely to get it. Anything short of that, you are unlikely to have it removed.
Okay. Right. So we have made the definitions as we show on there. The child's welfare is taking exceptional circumstances, requirements to change conditions, time frame for assessing the request. This one is saying no service standards apply to the assessment of whatever you qualify to change the conditions attached to your permission. Case workers will make reasonable efforts to decide your request promptly, especially if it involves a child or you are street homeless, disabled, or otherwise in vulnerable circumstances. So then my question is, how long does it normally take?
So let's deal with the substantives before we go to discretions.
Okay.
So the substantive is that there's no standard time.
Okay.
What does it mean? I'm going to put it this way, but in that, yeah,
Mm-hmm.
more or less, a beggar has no choice.
Has no choice.
You bring it to us whenever we are ready. We'll deal with it for you.
Mm-hmm.
So this has nothing to do with I'm going to try, unless, of course, there is danger of death or some extreme hardship.
Mm-hmm.
Then you have to take another step to have it expedited. So you say there's no standard time.
Okay.
And so whenever it's ready, they will. But case workers are advised to do what?
To make reasonable efforts to decide promptly.
What it means is that this is where I will rely to support my client. I will say that if after, say, 3 months it's not coming, I'll say that the reason for this is to avert hardship.
Mm-hmm.
I'm aware that the policy has no standard time. However, I'm equally aware that case workers are reminded of the need to deal with such things promptly.
Mm-hmm.
3 months is beyond normal. Can you take action?
So then you issue a PAP, a pre-action protocol on that one, isn't it?
Yes.
Okay.
Or you make a complaint.
Right. Right. Okay. And they're saying you can get help completing the form online, but I would advise you to speak to a reliable lawyer, a lawyer who knows what they're doing, and I recommend BWF solicitors to help you deal with that. And if you would want to speak to BWF solicitors, you can call them. The number is at the bottom of the screen, 0208 493 7340. In Ghana, their number is 00233 55589 5959. Emergency situations, you can call 077 61884. Or if you want to speak to lawyer Charles Asma himself, just call on 07947 636037. 07947 636037. I know at this point in time you may have your question and some concerns to bring up. I will invite them right after this.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Yes, welcome back, and thank you for sticking around. I mentioned that we had a nugget, something I needed you to know. So I want to quickly look at that. Then I'll give you the scenario and your advice on what would happen in that situation. So let's pick up the nugget and see what we talked about. I read to you, and by courtesy of BWF solicitors, I said, and I asked you, did you know you may be entitled to compensation if you were wrongly detained at the airport? The Secretary of State has the power to detain and examine every migrant who arrives in the UK at the point of entry. However, that must be balanced against the benefits of swift and fair decision making on entry. Where the Secretary of State for Home Department goes against her published policy, it may render the decision to detain unlawful, leading to the award of compensation against the Secretary of State. And that's this case, Artazim versus the Secretary of State for Home Department 2025, England and Wales, England and Wales Court of Appeal case number 347. So then I have this question to ask you. And it's a scenario that I'm going to bring up and ask you a question about it. Let's pick that one up. Yes. Abdullah Bruni arrived in the UK on 15th March 2025 at 5:30 a.m. as a dependent of Kofi Bonsam, a skilled worker. Upon arrival, she was questioned about her marriage. She was subsequently detained after her visa was cancelled. She was given a cancellation letter stating that her marriage certificate was suspected to be fake. She applied for an administrative review. She was granted bail after 7 days in detention. Abna Bruni sued the Secretary of State for Home Department for procedural unfairness and compensation for unlawful detention because she was not giving a minded to the letter before her visa was cancelled. So look at the situation quite critically well. She arrived in the UK as a dependent of Kofi Mensam, who is a skilled worker. She was questioned about her marriage. She was detained after that, after her visa was cancelled. She was given a cancellation letter stating that her marriage certificate was suspected to be fake. She applied for an administrative review and she was granted bail after 7 days in detention. Abena sued for procedural unfairness and compensation for unlawful detention because she was not giving a minded to letter before her visa was cancelled. Will she succeed in this action? Yes, no, and yes. Yes, because the process of cancellation of a visa was unfair. No, because she didn't answer all the questions properly. Yes, because she already had a visa and should not have been detained. Think about that. I'll come back. Now, let me go back to lawyer Charles Asma. We're looking at steps to take to get the no recourse to public funds taking off your immigration status. Lawyer, we've looked at the definition of no recourse. We looked at who is exempt from enjoying public funds. We have looked at public funds. You have explained that. Then you have explained what we need to really consider our incoming and our outgoings, and the situation where probably potentially we would become destitute. Are these all the things we need to know?
So largely, yes, then that will support your case. But there is a vital item that you
Lord,
need
please don't
because
do this. We don't like maths.
yes, but you can see that to be able to make a comparative analysis of your income and expenditure,
Yeah.
you must be able to know the numbers and see where the numbers favor you.
Okay.
And I mean, whenever somebody comes to me for fee waiver or no recourse condition removal, I pick my calculator
Okay.
and I say, let's do the maths. Whether your income will be less or more or equal.
Okay.
We list all of them. I will do punch, total. Punch, total. A equals to B. A minus B equals to whatever. Then I say you are likely to win, you are likely to lose, whatever. Then a decision will be made from there.
Also, so in this case, when you have done the figures, when you have done the comparison, when you would have told the person whether they could qualify or not, when the
Yes,
person has understood the definition of destitution, the definition of public funds, what they can apply for, what they cannot apply for, and all that, the decision is this is what your situation is. You can go ahead because you have a chance of winning. You may have to stop because you don't have a chance of winning, and the person will have to make that decision, isn't it?
yes. And that is what we do. We always assess your case and give you merit threshold in terms of chances. There's something called realistic prospect of success.
Okay.
If there is realistic prospect of getting it removed, then we go forward. If there's no realistic prospect based on what we see, then it is possible that you have to go back and do your job properly and come back. So wait for another 6 months or some time to come back. Because if, for example, your bank statement is open to public use and there's so much flooding in,
Mm-hmm.
you can't say they are not yours. So you cannot make a case out of it that, oh,
Out of
yes,
it.
no mine. Somebody came to me some time ago and said, oh, I'm doing 2 jobs. And I say, I've seen in on your bank statement that you are doing 2, 3 jobs. There's another one. So 4 jobs. They said, oh, this one, know me. And I said, there's nothing called know me. Only you can use your NI to work.
Right.
So you can't say this is know me. If
This
it's
is not
know
me
me,
now.
then
Once you
somebody
appear
is
on
using
your
your
statement with your name on it, then it's
exactly.
you.
Then if somebody is using your thing to work, go and report them
That's
so
right.
that they stop. Otherwise, you can't say it's not you. And because of that, that may go against you. So somebody like this, they have to wait till they have become destitute or imminent destitute, where the income has gone down and
Mhm.
expense stays the same, or the expense has gone up and the income is staying the same. Then
So
per
the
the
question I would obviously ask following this is that um, if I apply the first time and it doesn't succeed, when imminently or my circumstances change, or imminently I may become destitute, can I do the application again?
yes, there's no limit as to how many applications to put in. If
Okay.
they refuse the first one, somebody will say, how long will it take for the first to be refused?
Hmm.
Remember the case, the policy says that there's no time limit. However,
That's right. Yeah.
uh, they will make prompt assessment as they are required to make and come to you. So give and take 3 months, 4 months, okay? You some people get it before, some after. If it's delaying unduly, we chase it. But the key thing is if you are rejected once, you can go again and again and again.
And again,
At
again,
any
until.
point in time, you have to show that you meet the criteria.
Then again, I'll ask the various things that we need to show. Your income and expenditure for your income and expenditure for 6 months, your bank statement for 6 months, your pay slips for 6 months. You show your tenancy agreement that shows how much is going out, and you prove all the expenditure and the rest of it. Do all have to come together once, or I can use, say, my bank statements and my expenditure outline for that rather than bringing everything in place? So if I have my pay slips, I can use that alone, or I should combine all the rest that have been stated.
Thank you. Who stated all the others?
It's in the guidelines there.
So we have to follow the guidelines.
That's a lot.
But you want it.
Yes.
There's a reason they want you to prove it. Who will prove the case?
Me.
So you have to follow the long list.
So I can't even say I have, if there are 6, I can provide 5. Wouldn't that be enough?
Yeah, but the point here, there are two crucial bits. The income aspect, you have bank statements and pay slips. The bank statement will corroborate the pay slip income.
Mm-hmm.
There are certain incomes you can't. For example, your child's father is giving child maintenance or some support. That one, it will show that money in your account. You have to explain where it came from
It came from.
and the fact that it has stopped or is going to stop.
Okay.
But bank statement, let's say you have your bank statement showing that ABL Limited paid you, say, £2,000. And we can see the trend every month, ABL. The
Mm-hmm.
question is, what shows that ABL pays this money? How do you prove that bit?
Mm-hmm.
Pay slip, isn't it?
Yeah.
And you can't say that ABL doesn't give you pay slip. Fine, if ABL doesn't give you pay slip, we can then make a case that there's no pay slip or the pay slip cannot be accessed, and so this is showing it's from ABL.
Okay.
But otherwise, the more the better for you. When we go to the expenses, again, the expenses you have to show that you owe money, and that's why they are taking £100 every month. You are owing this, you are owing that, there is this, there is that. All the bills you have, including after school club for your child, including child, whatever, whatever, everything had to wait.
Mm-hmm.
Sometimes you may not have the evidence, but it will show on the bank statement that will highlight and explain or annotate it. But
Okay.
when you have the evidence, it's better because the caseworker wants to see evidence, proof.
Okay. Well, folks, I think the advice is clear, and we are assured that when you visit BWF solicitors, they will give you expert advice. They will tell you, in fact, they will do the assessment with yourselves and weigh your chances of success. If you won't succeed, I don't think they will tell you to go ahead. If you will, they will tell you, let's push it. And lawyer has also said that if first you don't succeed, try again. Lawyer Asma has helped us with that. But let me go back to my question and the scenario I posed to you. Abna Bruni and her situation. Will this action succeed? I think, let's see, if we have a few answers online, other than that, I was going to ask Lawyer Asma straight away what Abner's situation would be. If we have a few of the answers, please let's drop them on the platform. Let's see what anybody says. But Lawyer, we'll be coming back to you. Abner Bruni and Kofi Bonsam's situation. Would Abner succeed? Vida says yes, because she already had a visa and should not have been detained. That's Vida Ama. Priscilla says number 2, no, because she didn't answer all the questions properly.
I,
Okay, let's pick up another one. Emmanuel Pia says yes, because the process of cancellation of a visa was unfair. The next one, we have Susan Morgan, who says it's number 3, yes, because she already had a visa and should not have been detained. Okay, for lack of time, let me go to Lawyer Asma. Lawyer, if I said Abner's situation, she will succeed because X, Y, Z, what would be the correct uh, answer for Abner to just get her to be satisfied that what I'm putting in would either succeed or not?
yeah, so can we take the question and there's something that I want us to pick
Okay.
to conclude where we are. This is
No,
the
no, not
question
this one.
itself, right?
Yeah,
No, no,
okay,
this
yeah,
no.
this one.
Th- th-
It says Abner Bruni arrived in the UK on 15th March
but
2025 at 5:30 a.m. as a dependent of Kubu and summer skilled worker. Upon arrival, she was questioned about her marriage. She was subsequently detained after her visa was cancelled. She was given a cancellation letter stating that her marriage certificate was suspected to be fake. She applied for administrative review. She was granted bail after 7 days in detention. But she went on to sue for procedural unfairness and compensation for unlawful detention because she was not given a minded to letter before her visa was cancelled.
So there's something there. It says that she claims that she wasn't given the minded to cancel.
Yeah.
What does the rule say? The rule say that if you suspect that somebody has obtained visa wrongly
Mm-hmm.
by deception or any other means, and you
Mm-hmm.
intend to cancel, put them on notice.
Yeah.
And that's the procedure. If you don't do that and you go ahead to cancel, even though you've canceled, the person will turn around and say you didn't do your job properly. And so
You didn't treat me fairly.
there's always the need to tell them that we intend to cancel, which is minded to cancel
Mm-hmm.
notice. And so on that basis, we are looking at the fact that she cannot, the Secretary of State may be right to cancel, but the fact that they didn't follow their own policy, it would have been improper within the rules.
Mm.
And so the answer will be number one.
Well, as we have it, the answer is number one because it wasn't. Can we put it back on so people will know what the thing? Yes, because the process of cancellation of a visa was unfair. She was not giving minded to cancel letter, and that procedurally was wrong. Well, it's been a very interesting discussion this afternoon on step-by-step process of getting your no recourse to public funds condition taking off your immigration situation. Lawyer, as our tradition demands, what did we actually look at?
Thank you very much. So just to add to the answer to our nugget,
Mm-hmm.
so first was the procedure to cancel. But even though the procedure was wrong, there's something they did to this person. They detained her, right?
Yeah.
So it is not even just the cancellation, but the fact that the person has been wrongly detained.
Okay.
And so compensation will be not for the cancellation, but the detention. Because you can't detain somebody if you haven't told them why you are detaining them.
Right.
And so you tell me that you are canceling it, you cancel it, and you ask me to go home by calling me to be detained, to prepare me to go home.
To go.
But you didn't do certain things, and so you also not be right to say that you want to do this or that. So remember, this is based on the nugget itself, where somebody will be wrongly detained and the person will get compensation from the government. And this is a particular case. You are detained because they said you have used deception. They didn't tell you that. They canceled your thing and they arrest you to detain you. But is it fair? We said no, it
No.
is not.
Okay.
Now, our conversation today has made us to know that you can apply for no recourse to public fund condition on your visa to be removed.
All right.
In doing so, you have to show that you qualify, in that you have limited leave to remain with no recourse. We are not talking about visitors, we're talking about anybody else. Then you also have to prove that you have not been able to meet your essential living needs. So you check your income, you check your expenditure, all your bank statements, all your bank accounts, your children, and anybody in the house, you have to put them together. And 6 months of each bank statement, including savings account, including the ones that are dormant, bring all together. You assess against the expenses every month for yourself and for your household. If the expense is less than the income, your chances are very, very limited. If the expenses are more than the income, your chances are high. If the expenses are equal to the income, but things will change and the income will drop, then you have to point it out that even though it is equal now, it's going to be lower than my expenditure from tomorrow going because of things that are likely to happen. Again, you have to show that the expenses are normal expenses, not extraordinary expenses that you can avoid. And so, if they are not your essential expenses, you will be unable to claim them to offset against your income. Remember that all the money in your bank account or on the bank statement will be deemed to be your money. And so, if somebody is putting their money into your account because they want to save money through you, or you are saving their money for them, the caseworker will not think that you are just somebody's money keeper. They will think that the money is yours. So bear in mind that before you are ready to do this, everything is on point and everything points to you, so you can make a stronger case. Where you have a child involved, it makes the case easier because the child needs will be paramount. Where there's no child, and you have to prove that as an adult you are destitute or you are going to be imminently destitute. This is the conversation for today. Thank you.
Well, thank you so very much, Lawyer Charles Asma. You have been so gracious. And I keep saying that we don't take it for granted at all because your Saturday afternoon is often time taking. And we say thank you. And thank you to BWF Solicitors for the kind support and the education we give to the community. So, on behalf of the production team, I would want to say thank you very much once more, Lawyer Charles Asma, and to the senior partner, VWS Solicitors, Uncle Ben, to Auntie Cynthia, and all the members of staff and the lawyers at BWF Solicitors, both here in the UK and in Ghana. And to you out there, thank you very much. Without you, we wouldn't have had a program. And on the basis of that, I want to invite you to come join us again, same time next week on the same platforms at BWF Solicitors on Facebook and at BWF Solicitors on YouTube, and also at BWTV, both on Facebook and YouTube. So we have another encountering edition. Professor Day, Emmanuel, Sheila, Ankara, and